First matter to come before us this morning is State of Ohio versus Raymond Dennard. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for a rebuttal. If you're the appellant and wish to reserve any time for rebuttal, if you let me know when we get started. I'm keeping the clock this morning. I can keep you apprised of the passage of time. We've read the briefs. We're ready to proceed when you are.
Thank you, Your Honors. Good morning, Your Honors. My name is Attorney Denise Wells, and I represent the appellant in this matter, Mr. Raymond Dennard. In my time before the court today, I will address the evidence that was presented at the trial court in order to support the sexual predator classification hearing that was had in this matter, as well as the effectiveness of the trial counsel. Your Honors, at the time of the indictment, Mr. Dennard was indicted for 2 counts of kidnapping, 2 counts of rape, and 2 counts of aggravated burglary. This incident occurred in 2001. Therefore, the old Megan's Law would apply in this case. It was 14 years later that Mr. Dennard was indicted on these cases, and he ended up pleading guilty to the charges at the trial level, and the court proceeded at sentencing to have a sexual predator classification hearing. Now, under RC 2950.09b3, the statute requires the trial court, to have the hearing for the sexual predator classification prior to sentencing. The court did not do that in this case. Rather, the court instead issued its sentence, and then after the sentencing, then proceeded to the sexual classification hearing. In RC first of all, in State versus Eppinger, the Ohio Supreme Court adopted a model procedure that the trial court should follow when it is conducting a sexual classification hearing. And the reason why they did this is to ensure full compliance with the applicable principles of law and to provide fairness in these such hearings. The model procedure provided by Eppinger had 3 critical components. The 3 components or 3 objectives was, one, that it is critical that a record be created for review at this hearing. Number 2, an expert may be required to assist the trial court in determining whether the offender is likely to engage in the future in a sexually oriented offense. And then 3, the trial court should consider the statutory factors listed in 2950.09 and should discuss those factors on the record with particular evidence and factors upon which it relies in making its determination regarding the person's likelihood of recidivism. Now, the evidence in this case does not support a sexual predator classification. The trial court here failed to follow the Eppinger model, and as well as did not address all of the factors as set forth in 2950.09. The trial court did not create a complete record for review. When the prosecutor or the state of Ohio was permitted to make statements at this classification hearing, the only thing that was put on the record is that Mr. Dennard had 13 prior convictions and stated that the crime was by nature cruel. So the court went on to have this hearing, and the first objective was not satisfied of the Eppinger model. The second objective, an expert was not employed by the court. There was no report generated whatsoever to determine whether the appellant, or Mr. Dennard in this case, was likely to engage in the future in sexually oriented offenses. And with respect to the third objective, the trial court did not state for the record that it had considered the factors under 2950.09, and the trial court did not specifically address the statutory factors as required. And only 2 of the factors that are enumerated in 2950.03 were analyzed by the trial court during this hearing. The trial court did not discuss which factors made it more likely that Mr. Dennard would commit a future sexual offense. Now, keep in mind that at the time, in 2001, he had 2 prior convictions for voyeurism. And so that's when the offense was committed. Therefore, we would argue that the court should look back and consider what his prior record was at the time of that offense.
But wasn't he convicted of another sexually related offense after 2001 and before he went to prison?
That is correct, Your Honors. And he, in fact, when he did go to prison in that matter, he was in a treatment. He was getting treatment for sexual abuse counseling or treatment. And
subsequent to his 2001 offense, he did commit another offense, sexually related offense.
Afterwards, yes, but not before. With respect to the factors set forth in 2950-09, here are some of the factors that the court should have considered. Number one, the offender's age. The court simply stated on the record that Mr. Dennard was 48 years old, but did not analyze the factor nor discuss whether or not it made it more likely that Mr. Dennard would reoffend. And number two, the offender's prior record was taken into consideration, but again, the court did not analyze this factor nor discuss whether it made it more likely that Mr. Dennard would reoffend. 3, the age of the victim was never discussed or analyzed. 4, whether the offense involved multiple victims was never discussed or analyzed. 5, whether the offender used drugs or alcohol to impair the victim was never analyzed. 6, whether the offender completed any sentence imposed for a prior criminal offense or participated in available programs for sexual offenders was discussed but was not analyzed to determine whether this factor made it less or more likely that Mr. Dennard could reoffend. The argument could be made that because he had involved himself in these available programs, that in fact he may not have been likely to reoffend, but the court never addressed those issues. And number 7, any mental illness or mental disability, that also was never discussed. Number 8, in the statute, the nature of the offender's sexual contact or interaction with the victim was part of a demonstrated pattern of abuse. That was not discussed. That was not analyzed by the court. And I have 2 more factors. One, number 9, whether the offender during the offense displayed cruelty or made one or more threats of cruelty. It was discussed by the trial court, but the trial court did not analyze whether this factor made it more likely that Mr. Dennard would reoffend or not. And then finally, any additional behavioral characteristics that contributed to the offender's conduct were also not discussed and analyzed. So basically, the court just mentioned a few items in passing, but there was no critical analysis that was ever conducted on the record. So not only did the court not comply with the statute, but also did not comply with the Eppinger model that has been set forth by the Ohio Supreme Court. Since no clear and convincing evidence was presented relating to Mr. Dennard's likelihood to reoffend, that the evidence is insufficient to classify him as a sexual predator. My second argument, Your Honors, is the fact that the trial counsel was ineffective. Now, the standards, as you well know, was that counsel's performance fell below an objective standard of reasonableness and that prejudice arose from the counsel's performance. The argument here is simply that the trial court counsel failed to apply for an expert witness in this case. They failed to address the court, although this, as the state pointed out in their brief, that counsel was retained in this matter. It was not court appointed, but certainly if there was some sort of issue as far as indigency, they could have filed an affidavit of indigency and asked the court to provide an expert witness, or simply if he did have the money, they could have gone forward and gotten this witness, and they failed to do so.
Aside from that, counsel, how do we know from this record that defense counsel didn't contact 3 or 4 experts who were simply unwilling to testify that this guy shouldn't be labeled as a sexual predator?
We do not know that, Your Honor. The record is silent.
I mean, they may have, but
they
you
may
just couldn't
have,
find one.
They may have, but in the record, you're absolutely right. There's nothing to indicate whether or not that happened. But had there been an expert, the expert testimony would have assisted the trial court in proper classification here. And so And keep in mind, again, that the offense occurred 14 years prior to this offense. So I think, given his history, both criminal and otherwise, that an expert would have been something that they could have greatly utilized. Your Honors, we would ask the court to, that these facts mandate the conclusion that Mr. Dennard was denied most importantly, was denied a proper classification hearing, both for 3 reasons. 1, because it occurred after sentencing. 2, because the court failed to analyze any of the statutory requirements under 295009, and 3, it failed to adhere to the Eppinger model, which again was set forth to allow for full compliance by the courts. Thank you.
The classification occurred right after the sentence.
It did,
Right.
Your Honor.
Okay. And that's not an assigned error. The timing of the classification is not assigned as error.
Well,
Just talking about the manifest weight.
Well, right, but the statute does prescribe that it should occur prior to the sentencing hearing, and it was not done.
Did anybody object to it being done subsequent to the imposition of sentence?
I don't believe so, Your Honor.
Right. And at the time the trial court imposed the sentence, the trial court had the benefit of a pre-sentence report.
That is correct.
Is that part of this record?
It is. However, the court didn't address any of those issues at the sexual classification hearing like it should have. So the record is silent as to what the court actually did consider, because simply stating the age and what happened, what his prior history was, it didn't actually explain what the prior history was or why that prior history made it more likely that he would reoffend. So there were several, there's a lot missing in the record that had the trial court placed it on the record and analyzed it properly, that we believe that the classification outcome would have been different. Thank you.
May it please the court, my name is Natasha Guerrero and I represent the appellee of the state of Ohio in this matter. First, with regard to the actual timing of the hearing on the sexual classification, the statute doesn't indicate having the hearing prior to sentencing. However, there is case law which indicates that this is more of a convenience and to have a more orderly process within the trial court, and that it's not jurisdictional. That if the court does not hold the classification hearing prior to sentencing, the statute does not indicate that the trial court then is therefore without jurisdiction to hold a sexual classification hearing. Next, with regard to the actual evidence presented to the trial court, with regard to the factors that the trial court was required to consider, there was a pre-sentence investigation report that was provided to the court that had a majority of the factors that were required to be considered. And again, it's this court in Troutman stated that the trial court is required to consider each of these factors. The trial court is not required to list every single factor in the sentencing hearing itself. In the classification hearing itself. And again, that pre-sentence investigation, along with the victim being present, providing the court with the facts of what took place that evening. The pre-sentence investigation contained Mr. Dennard's prior criminal history. It contained information with regard to his age, sentences that he previously served with regard to sexual offenses. And just from the information, there was no allegation that there were multiple victims or that the victim was in some way impaired by Mr. Dennard. That was never alleged. That was obviously not within the reports there, because that was not a part of what took place. Also, within the pre-sentence investigation. There was a section for mental illness or for the defendant, and that contained no information that he was suffering from any sort of mental illness, and his attorneys never alleged that to be the case here. And also, his attorneys also did provide the trial court with a sentencing memorandum, which contained some other factors for the trial court to consider with regard to some things that may help to explain his particular behaviors. So the state would argue that in combination with the victim's statements made by the state, as well as that pre-sentence investigation, the trial court had competent, credible evidence in order to make a determination with regard to Mr. Dennard's sexual offender classification, and that it was in fact supported by the competent, credible evidence. With regard to the second assignment of error in this matter, that being ineffective assistance of counsel, here in reviewing the record, his attorneys clearly were able to present to the trial court all those factors that they deemed to be helpful to the defendant in the sexual classification hearing, provided information with regard to his age, and made arguments that at the time of his release, his age would be a preventative factor in any sort of recidivism, and pointed out that he did receive some sexual offender treatment in 2012. With regard to the aspect of having an expert opinion, as counsel previously noted, Eppinger refers to an indigent defendant, and the trial court in that matter appointing an expert. Here, the record clearly shows that Mr. Dennard actually hired his own counsel here, never filed any sort of affidavit of indigency. Therefore, any sort of appointment of an expert would be unwarranted because there was no indication that Mr. Dennard actually was indigent. Furthermore, there is ample evidence within the record, as I previously stated, that the trial court could in fact rely on when making its determination of the sexual offender classification. The PSI, which contained all of those relevant factors, the state making its statement, the statements made by Mr. Dennard's counsel, as well as those statements of the victim. Therefore, in this case, it was not necessary for the trial court to order an expert opinion because there was ample evidence from which the trial court could make its determination in this matter. So based upon the information that was contained, it was not necessary for the defense counsel to have to go and seek out an expert in this matter. And the state would submit that Mr. Dennard did have effective assistance of counsel in this matter. Therefore, based upon all the arguments made here and also within my brief, the state would request that this honorable court uphold the decision of the trial court in this matter. Are there no questions? Thank you, Your Honors.
Counsel, you have about 3 minutes remaining.
Nothing further, Your Honor.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on the website. Thank you.
Thank you.